murder, contrary to section 203 as read with section 204, Your Honor, of the penal code laws of Kenya. Your Honor, on the
I'm recording, so I can do that. Yes, on.
Your Honor, the circumstances are that on the 29th day of October, the respondents, together with the deceased, Your Honor, were acting on a tip-off
All policemen.
all police officers attached to my police station, Your Honor, including the deceased. They were acting on a tip-off on the 29th day of October 2025, where they responded to a call at Msikiti area, Your Honor, my township. And on that responding to a call, the deceased was shot on the chest by unknown persons, Your Honor. The same was
Person or persons?
unknown persons in the first place, Your Honor. In the first place. The same was recorded at OB number 4 of 29 October, Your Honor, 2025, for a case of shooting stroke death of a police officer, Your Honor.
Go ahead.
Your Honor, the respondents, together with others, responded to the other officers who were not here, and the deceased responded to the scene where there was an allegation of a robbery violence involving a motor vehicle, KDU 614, Isuzu FRR, where at the scene,
1 second. Registration number?
KDU 614G,
Delta uniform?
Kilo Delta uniform, 614 Golf,
Mitsubishi.
Isuzu FR, Your Honor,
Isuzu.
FRR,
FRR.
where they found the same at the scene, where some over 10 loaders were offloading tires and hardware goods, Your Honor.
Some? How many loaders?
Over 10 loaders, Your Honor. The respondents, together with
Well, offloading what?
the merchandise goods, Your Honor, that is to which tires and hardware goods, Your Honor.
Yes.
The police officers come respondents, Your Honor, responded to the scene, where the loaders scattered in different directions, and in the process of responding to the scene, the gunshots were heard.
1 second. Yes, gunshots were heard.
The gunshots were heard, and the deceased died on the spot at the scene, Your Honor.
Yes.
Your Honor, the 4 respondents are serving police officers who are issued with a firearm, to wit pistols of different caliber. There was a Seska and Jericho. As per my
Issued with firearms?
being police officers, they were, while going to the scene, they were armed with firearms
You said of different calibers.
of different calibers. There's a Jericho and a Seska, Your Honor, but the small pistols.
A Jericho pistol
That is for the 9 Mike, Your Honor.
and the Seska,
Seska, then to bracket 9 Mike for both.
9mm.
Yes, Your Honor.
Yes.
As per the arms movement for my police station, Your Honor. Preliminary investigations indicated, Your Honor, myself, I was at the scene during that time as the investigating officer, Your Honor, the whole night. It is believed, and myself, I believe, Your Honor, the four respondents interfered with the scene by reconstructing the scene where they took the deceased pistol, placed it beside him, and attached. Placed the
One second. So they interfered the scene by reconstructing the scene
They reconstructed the scene
and took the
the deceased the firearm, pointing it on the chest side of the deceased where he was shot, to indicate that the deceased shot himself, Your Honor.
yes.
In a general public law, Your Honor, public view, you cannot be shot while armed. You carry your gun, then you die with the gun still holding the tag there.
You're now giving evidence. What
Okay.
is your application?
Your Honor, owing to the interference of investigations, Your Honor, because these are the serving police officers, I would request this honorable court to grant me 21 days, owing to the fact that there was a bullet that lodged at the chest of the deceased, Your Honor. It has not been retrieved.
So you seek 21 days to do what? To have the respondent?
To have the respondents be detained at Naivasha police station. First, Your Honor, I had confiscated their firearms. They are yet to be submitted to government ballistic forensic analysis. Postmortem is yet to be conducted, Your Honor.
You're moving very fast. So you included their firearms, they are yet to be subjected
To ballistic forensic analysis.
Yes.
There's a bullet that lodged on the deceased body. Supposed to, we are yet to carry out the postmortem to retrieve the same, again to be subjected to forensic ballistic for the analysis.
When is postmortem scheduled?
I'm yet to discuss with the family members, Your Honor. Your Honor, during the time of robbery, when the driver was being robbed off the motor vehicle, Your Honor, the motor vehicle was driven to the scene by people believed to be police officers, because the driver up to now has not been traced and he was kidnapped, Your Honor. We had to trace him, record his statements. Because it's believed the robbery was orchestrated by people who must have been activated by police officers, serving police officers, and I believe the respondent side of them.
Yes.
There was also a loose firearm on the public domain, Your Honor. We are still looking for it. It was
Lost.
There's a loose firearm on the public domain that was being used. That's being used outside, and believed to have been used by the respondent in couch with others who are not before this court, Your Honor. And those are my humble requests for this honorable court, Your Honor. Having been alive to the constitutional rights of the detained accused persons, Your Honor, as enshrined in Constitution, Your Honor.
Yes.
That's all, Your Honor. The rest I beg the Honorable Court to consider my application for the interest of justice for the deceased officer, Your Honor, plus the family. Thank you, Your Honor.
Anything you want to add, prosecution, before I give this one?
Just to Your Honor, I'm in support of the application. And also what I've got from the IO, we are yet also to establish the motive, whether the motive was robbery or murder.
1 second, we are in support of the application.
Yes, for the application.
So we are here to
establish the motive.
establish the motive.
And also the fact that the driver is at large. We are not sure whether he was kidnapped. He is yet to record the statement, and who we believe the driver is a crucial witness to this matter. And lastly, also the ID parade has not yet been conducted. Therefore, it is safe that this court gives the IO more time while the respondents are in custody, which the court will give us directions on the days. That's all.
Understand?
Thank you. Mr. Officer, look at paragraph 6 of the affidavit.
You are cross-examining.
Yes. I'll cross-examine you.
Let's cross-examine. Yes.
Confirm from paragraph 6 that you are saying the deceased was shot on the chest by unknown people.
Yes, Your Honor.
Thank you. Look at paragraph 8. In paragraph 8, you are confirming that this incident is likely to have happened at 0100 hours.
Yes, Your Honor.
That is past midnight.
Yes.
Look at paragraph 8.
Yes.
Continue.
Paragraph 8, you are saying it was an alleged robbery.
Yes, Your Honor.
Paragraph 9, you have told the court that these respondents,
Your Honor, in response to the defense counsel, Your Honor, in paragraph 8, I've not mentioned about the robbery. I think I'm alive to the facts in paragraph 8, Your Honor.
what have you told?
I don't know
What is it about KDU 614G?
the suspect found motor vehicle registration number is whosoever being offloaded tires and hardware goods. Where the challenge offloaders, Your Honor, already explained it to the court. The court is privy to the information because the court has my
Well,
affidavits on affidavit.
let's go to paragraph 9. Confirm that these officers were armed with police pistols.
Definitely, Your Honor.
And confirm that you have taken their weapons for analysis.
Yes, Your Honor.
On that question on analysis, where have you taken the weapons for analysis?
Ballistic forensic analysis at PCA recorders, Your Honor.
Have you already taken them?
Yes, I've already submitted the same visa. I think I have a by moving the court with facts, which can be confirmed by the Office of the Director of Public Prosecution. The document was received, Your Honor.
All right. Show to the court what is their role at the ballistics offices. What are they supposed to do when the experts are doing their job?
Your Honor, as I had mentioned in my affidavit, the respondents, the serving police officers, are working in cahoots with other.
I've asked a simple question, Mr.
I think
At the ballistic, it's a laboratory.
with the ballistic, Your Honor, they have got nothing to do with the ballistic.
Number one, we have dealt with the question of ballistic. Let's go to number 10, issue number 2. We have brought it in paragraph 10. That they have reconstructed the scene.
Yeah, the scene was reconstructed.
Look at paragraph 6. No, paragraph 8. What time did the offense was committed?
Paragraph 8, Your Honor, for my affidavit?
Yes,
For
yes.
my affidavit? Paragraph of my affidavit is not indicating time, Your Honor.
It says paragraph 8,
001.
01.
Or zero-
The offense was allegedly committed around 01,
01:00
hours. And the offense, the scene was visited when?
or on the same day.
On the same day.
Yes.
And nobody was there when the alleged shootout happened. True?
I don't understand what you mean by nobody was there. Can come clear about the same.
Was the scene captured prior to the reconstruction? So that you are saying this was the scene, but now this is what has been reconstructed.
I'm alive to the statements of the witnesses, Your Honor. That's why I was responding to the statement and doing my affidavit for request for detention.
Thank you.
And if the defense counsel is in need of the same.
No, it's okay,
will be
it's okay, it's
provided.
okay, it's okay. Confirm that paragraph 10, there is no annexure to support that. Before the
Reconstruction, Your Honor, we have the witness statement.
It's okay, I've only asked, is the court having?
I don't know whether, because it was not the time for hearing, I don't know whether the court needs.
It is either there or not. Only I've asked, is
Your Honor,
it there?
We have it's there.
Is it provided to the court?
No, it's not provided, but we have
Thank
a
you,
statement.
thank you,
already.
thank you, thank you.
Yes.
Thank you, Mr. Let's go to paragraph 11, the third issue. The third issue, why you want these officers detained is because they interfere with witnesses. True.
Yes, Your Honor.
Do you have any form of evidence to show that?
When the court allows me, I'll
No, for now.
Your Honor,
For now, is it there?
yes, Your Honor, with due respect to the presiding court, Your Honor, there's still one suspect who's a public who called Mr. Mongai, who called the officers to the scene, and we believe those are the people we are looking for who are working in cahoots with the respondents, Your Honor. And I did not want to disclose it here because it's a matter of
My question, you have explained why it is not there. I've only asked, is it annexed? It is a question of yes or no. Is it there?
I don't understand your defense.
I've only asked one question.
Yes.
Do we have any statement attached to this?
We have it in court here. If the court
No.
need, we can provide. In
It's
respect
not
to the
there
same.
in this application. The court has this application.
It's done in my application. That's why I'm.
Very well.
That's an excerpt from the statement.
Let's move further. Paragraph 12. You have said that you need to do post-mortem. True?
Yes.
Are they required during post-mortem?
No.
Thank you. Paragraph 13, we have dealt with the question of ballistic forensic analysis. Look at paragraph 14. What are you saying the officers have committed? Paragraph 14.
Your Honor, in my affidavit, paragraph 15,
14.
I've talked about a robbery with violence because robbery with violence is what necessitated the murder, Your Honor.
So it is robbery with violence.
May I decide on the offense, prefer, Your Honor.
But that's okay, that's okay. Let's go to paragraph 15, last paragraph. What other reason do you want to give the court to detain them?
I think the reasons are already given out to the city.
Paragraph 15.
15.
Yeah, I've only narrowed to your paragraph.
Yes, I'm alive to the same.
What is the reason? In paragraph 15, interference.
You want to get the defense counsel.
Paragraph 15.
When it comes to interference of the witnesses by the respondents, Your Honor, most of the people they claim to be their informers, Your Honor, whom feared to record their statement before they were arrested, Your Honor, and now they are cooperating. Because the lawyers who are at the scene are known, they are friends with the respondents, and we try to reach them during that time, but they fear now they are cooperating, Your Honor. I don't expect to get a good results and a good evidence from them when the respondents are loose outside, Your Honor. These people are the trained police officers on firearm, and I already explained in court very clearly that there's a loose firearm outside that's believed to have been is being used by the respondents and other people who are outside, Your Honor. If left at this time of the active investigations, Your Honor, the deceased will not get any justice when the IO, the investigating officer, will be trying to contact the same witnesses, the same lawyers who the officers dispersed from the ground because they are known to them. Officers mentioned their names in their statements. They feared recording the statements when the officers were outside. That night state, the investigating officer, with the due respect to this honorable court, to request the respondents, Your Honor, be detained. I complete my investigation. There definitely they will be free.
Last question. Read to the learned court the paragraph you are talking of, a loose fire that is outside.
Sorry?
Read to the paragraph where
Your Honor, that is my preliminary.
It is not there.
I need not to include all.
I've only asked a simple thing.
I think
It is not there.
the defense counsel, I'm trying to explain to the honorable court
Yes.
question.
Yes.
And I want to elaborate for you so that you can have facts which you did not have.
Yes.
Even if your clients will be giving you facts, you already have some facts from the investigating officer. There's a loose firearm. Those are informations I need not to reveal them in court, neither in papers. So just take it aside, I explained it to you, Your Honor, for the consumption of your case.
Then that's all for cross-examination. I can do my submissions based on the
Thank you,
cross-examination.
Your Honor.
The officer can be discharged.
Yes. Inspector. Thank you, Your Honor.
Yes.
Your Honor, before I respond to the affidavit and the sentiments of the learned State Council, I wish to make an oral application that the 4 respondents be entered into a reasonable cash bail or bond terms on the basis that the reasons provided by the state to keep the officers, the respondents, in custody does not disclose any compelling reasons as provided for by the Constitution of Kenya and the Criminal Procedure Code. Your Honor, the state starts by saying the offense was committed, the alleged offense was committed at 0100 hours. And the scene was reconstructed. No material has been presented before this court. As provided for by the authorities of Dwight Sagare, where Justice Korir,
The authority of?
Dwight Sagare,
How do you spell that?
DWRIGT, DWRIGT, Sagare is SAGARY, where Justice Korir made it very clear that
Which Korir? Well done.
Justice,
Oh.
not your Justice, the lady Justice, Lady
Yes.
Korir put it that material evidence must be produced before the court to support an allegation of interference by the respondents. Secondly, the second issue why the state wants them detained is to allow the state to do ballistic analysis. This is a scientific process conducted by experts from the DCI to the exclusion of the four. They are not required. And therefore, detaining them on that reason is not sufficient. Third reason, Your Honor, why the state wants to detain them is in paragraph 11, that there are ongoing investigations and they'll interfere with the witnesses. The same authority I've referred to Justice Correa said that it must be demonstrated one, that they have actually attempted to interfere. And interference with witnesses is a crime by itself. Where the police will record a complaint of interference and charge whoever is interfering with the administration of justice. That is not before you, Your Honor. Therefore, that is mere apprehension that they are likely to. And in the case of J. Alden, the authority, the court is aware about all those authorities, and the state is aware about those authorities. Mere apprehension by the prosecution is not sufficient reasons to curtail the liberty of an individual. This has been dealt with in the case of Obado, the governor of Migori, the Michael Oyamo case that went to the Court of Appeal. The court upheld that if there is fear of interference, the trial court is clothed with the powers to impose conditions. The four respondents found themselves in Maimayu by virtue of them being police officers. It is work that took them there. The court, therefore, can order they be released on bail and keep away from my mind, either 100 kilometers away or 200 kilometers away. You know, also in the celebrated case of Oscar Sudi Kipchumba, Professor Judge Ngugi, then sitting in Nakuru High Court, told the state that Kenyans pay taxes to fund the police to do their job. The police cannot cry that they fear 4 simple Kenyans being out. This is a country, we have a very strong police force. If any of those 4 interfere with the witnesses, you know, the court will cancel their bond terms. And they are all police officers. They know that they must respect the rule of law. Therefore, Your Honor, paragraph 11 of interference is not a compelling reason. Your Honor, paragraph 12 has produced another reason the state wants you to use to detain them, that autopsy or postmortem has not been conducted. Your Honor, none of this is a trained pathologist. They are mere police constables. They will not even be required to identify the body because they are not family members. This is a scientific process done by medical staffs and police officers, plus the family. Therefore, that reason, postmortem can be done without them. You know, you have also been told about Section 14, the gravity of the offense. That if convicted or if they are charged, they are facing grave offenses of murder or robbery with violence. That was then, before 2010. After 2010, Kenyans enacted Article 49, 1H of the Constitution. And also enacted Article 150, Article 50 of the Constitution, that these are people presumed to be innocent. They have not been convicted of the alleged offense. And therefore, the gravity of the offense is not reason enough to detain these people. Your Honor, I urge the court to take judicial notice of the number of people who have been charged and have been acquitted. The reason why the judiciary was created is to see the evidence and convict if the evidence is sufficient. For now, the question before you, Your Honor, is whether there has been compelling reasons to deny these people their freedom. Your Honor, of the affidavit, it is my submission that the state has not produced any compelling reasons as to why they need 21 days in custody. These are all police officers. The deceased is a police officer. The notion that police officers cannot be released on bail by virtue of them being highly trained in the art of guns and investigation is condemning police officers and everybody in the disciplined force, that on the basis of their employment as police officers, they must be discriminated negatively. You know, before you are respondents, alluding that police officers are dangerous people. And in a week's time, 10,000 young youths are going to be employed into the police. It's telling Kenyans that it is a job not worth looking for. We have a duty to protect the image of the police and let them not be condemned because they are police officers. You know, you have been told there is a loose gun, a loose fire. All these officers were issued with 15 rounds of ammunition, and they returned all the ammunition back. A creation that there is another gun outside the guns they were issued by the police is far-fetched.
You're now testifying.
I'm only responding to that.
No, you're testifying.
You know, the issue of the loose fire is not in the affidavit. It is a creation to convince the court that these people acted outside the infrastructure supplied to them by the police. That is the guns and ammunition. Your Honor, I urge the learned court to enter into bail the four respondents and to put conditions for them not to report to to Mai, but they report to the investigating officer as and when the investigating officer wants them. All their records and data is in the hands of the National Police Service. They can't be a flight risk. They are serving police officers. And Your Honor, when you retire to write your reasoned ruling, the judiciary bail and bond policy guidelines provides for that minus compelling reasons, the respondents can be released on favorable terms. May the court find favor in my submissions. That's all.
Carol, you have something to say?
No, Your Honor, we can take your directions. I think much has been said. There's no point of being repetitive. You can take your directions.
Strangely, I am going on leave from Monday. Today is Friday, so you'll have to bear with me. I will deliver this at 3 p.m. I have to deliver the ruling at 3 p.m. because I will be going on leave from Monday.
That's
so the other alternative is if I'll deliver by 3 p.m.
3 p.m. is okay. That's fine.
Or 3 p.m.
Much better.
3 p.m. All right, now call our matters. Cause the next matter?
Criminal case E1133 of 2025, Alice Ongwe Detention.